This is Steve Beck. Welcome to everybody. I'm going to be joined this afternoon by my partners, Jim Platt and David Glazer, and we're going to talk about in-house counsel matters, really what we think is hot and interesting in hospital-physician relationships, and also sort of adding physician relationships with device companies. I think that I've got a couple of housekeeping things to deal with first. If you want to ask a question, you may see that in order to activate the chat box, you've got to click on the little thought bubble that should be at the bottom right side of your screen. And that'll allow you to ask questions in the same way we've always done questions in these webinars. But it may be a little bit unfamiliar to you in terms of how to turn it on. That's number one. Number two, we will be doing next month's webinar, and the plan is to talk about the physician fee schedule and the ACO regulations in some detail. So that should be an interesting presentation, and it will happen at the normal time, which is the second Wednesday, December 14th. David has just informed me December 14th is the date. So I hope you'll all participate in that, and we look forward to seeing you there. Okay, so let's get going. We're going to spend 90 minutes, and each of us is going to take a piece of this. And I want to start off by talking about transactions to integrate physician practices and hospitals, and some of the transaction structures that we are seeing nowadays. And this slide takes us through a few of the things that we're going to be talking about, and really sort of into what Jim is going to be talking about a little bit. We're going to talk about the differences between a stock and an asset deal in an integration transaction. We're going to be talking about an alternative, which is an asset deal including the purchase of personal goodwill, an asset that's owned by the physicians that own the clinic. I want to talk about a couple of alternative purchase integration options. One, the purchase of a minority interest by a hospital. Second, the purchase of an option by a hospital. And we want to talk a little bit about something very exciting that's happened in the ACO world. ACOs, from my perspective, just became interesting where they were not interesting before. Finally, we're going to go to some of the other integration structures that don't involve acquisition of an interest in the clinic, and those are, aside from the networks that really are part of ACOs, joint ventures and whole clinic PSAs or partial clinic PSAs. So let me start a little bit with this issue of stock versus asset deal. And I think what we're finding in the last couple of years is that while there was a period in which the value of a clinic in a transaction where the hospital was acquiring the clinic was quite depressed, that hospitals were in fact purchasing clinics at something close to book value of the clinic, not providing any sort of premium over the assets that are on the balance sheet of the clinic. We've seen transactions recently that have been higher value. And I think what happens now is that if there is a significant intangible value in the clinic, a significant value that's attached to the going concern, then most of these transactions, which are with physician organizations which are taxed as C corporations by the federal government, would result, if they are an asset-based transaction, in a large corporate level tax. And it's a corporate level tax in addition to the tax on money distributed to the doctor. So when you think about this and you say, let's pretend we had a transaction that had a value on a per doctor basis of that's equal to book value of the corporation plus $200,000 per doctor, each doctor would be receiving $200,000. It would go first to the corporation. The corporation would be taxed on the sale of its asset. The asset would have no basis, tax basis. So a corporate level tax would apply. Federal and state, that's probably going to be something in excess of 40%. So the $200,000 would result in an immediate corporate tax of $80,000. The corporation wouldn't have a deduction readily available to pay to offset that income. The corporation would then distribute the remaining $120,000 to the shareholders, and they would pay 35% tax on that $120,000. So that would result in probably another $30,000 in tax, let's say. So what would happen is, at the end of the day, the $200,000 would more than 50% be eaten up by federal and state taxes. Probably something like 60% of it would go. And the result of that is that the physicians are going to ask that the transaction be structured as a stock deal. If the transaction is structured as a stock deal, the hospital pays each physician for his or her shares of stock, and the physician gets the money directly, signs the stock over to the hospital, and is treated as the owner of a capital asset that he's realizing long-term capital gains on if he's held the stock for more than 6 months. That means the physician is going to be taxed at 15%. So in our example, if we had $200,000 of excess value, that's value that's beyond what the physicians have in tax basis of their stock, that $200,000 would result in a $30,000 tax. So the difference is $30,000 versus, in our case, something like $120,000 in tax. It's a huge amount, and the corporate level tax on a C corporation in an asset transaction, when we're talking about intangible value, eats up a tremendous portion of what the physicians see as their sort of necessary return in the sale of their business. So the importance to the physicians of structuring as a stock transaction, if there is a significant intangible value, is really high. So many times in-house counsel are going to be evaluating whether it's appropriate to do a stock deal. And there are probably a few things that need to be thought through in determining whether a stock deal is workable. One thing that is important to know is that, like many places in the tax code, you can't easily eliminate a tax and not have another tax appear someplace else. So in the context of a nonprofit tax-exempt organization that acquires a for-profit clinic in a stock deal, it may be that at some point the nonprofit tax-exempt organization says, we want to dissolve this clinic into ourselves. We want to dissolve the taxable company into the exempt non-taxable company. And interestingly enough, what happens when you do that is a tax may be applied to the taxable corporation before it disappears. And this is a consequence of Internal Revenue Code Section 337. Under 337, there is normally a no recognition of gain on the dissolution of a company into its parent company. If you're an 80% subsidiary, the subsidiary can be dissolved without tax. And 337 has a section that says, but this section doesn't apply if you're dissolving the taxable corporation into a tax exempt. So in effect, what happens in that situation is that a tax is imposed on the taxable corporation that's equal to what would happen if the taxable corporation sold all its assets for their fair market value. And if we've just had a transaction in which we said the fair market value was X, $10 million, let's say, and then the no corporate C Corp tax was paid on that because a stock deal was done, and then the hospital dissolves the corporation into the hospital, fair market value of the assets is going to look like it's pretty close to $10 million, and therefore there might be a corporate level tax applied to the corporation when it does the dissolution. That would be really parallel to the tax that might apply to the shareholders. So did we get out of the tax at all by doing the stock deal? And the answer is, well, we might. And it depends on whether you're actually going to ever dissolve into the exempt organization. It isn't really necessary if you've acquired the clinic, excuse me, to dissolve it into the tax-exempt organization. You can do it or not do it. Most taxable clinics don't pay corporate level tax because they don't have corporate level income year in and year out. And one can manage a professional organization in a way that doesn't result in a corporate level tax because there really isn't any income, and that could go on for a long period of time. It's also possible that after some period of time you'd say, well, we still are in a position where it's important to dissolve this clinic into the hospital's exempt organization, and a lot of time has gone by, and frankly, in some circumstances, that clinic may have lost money over that time period because things change between the time of the transaction and the time of the dissolution. If a long period has gone by, the assumption that $10 million, our pretend purchase price, is the amount of the fair market value of the assets may no longer be true, may no longer be a valid assumption, and it may be that we have to go back and say, what is the fair market value, evaluate that at the time of the dissolution, and pay a tax that fits. In any event, for in-house counsel who are thinking about what happens if we choose a stock deal, it's important to realize that this corporate level tax is lurking out there and may bite you. Now, a second issue that's important in the event of a stock transaction is the corporate practice analysis. I'm going to deal with this in a little bit more detail in a minute, but let me just set it up. The issue is that most every state, at least many states, have an ancient doctrine which says that physicians can't practice medicine in a corporate form. And there are a few exceptions to this ancient doctrine. One is they can practice in a professional corporation. But a professional corporation can only be owned in many states by physicians, can't be owned in some states by a hospital. Now, this, because I call it an ancient doctrine, it really is something that exists in the common law and has odd exceptions in every state. So some states have a hospital exception. In some states, that's a very limited hospital exception. Other states have a nonprofit exception. All of these in addition to the corporate practice exception for professional corporations. So you may or may not have a problem with whether the hospital can own stock after having done a stock deal. But that's an issue that's going to require analysis if we're trying to decide whether to do stock or asset. Another issue has to do with exactly who participates in the transaction. Stock deal adds some complication because it is a transaction with the shareholders. It isn't a transaction with the company. And the consequence of that is that the company or some negotiator negotiates on behalf of the shareholders, but the shareholders are the people who are actually transferring their shares and have to decide whether or not to do it. If a hospital takes over a practice and owns 100% of the shares, then it effectively has 100% of the control of that corporation. It can control what the board of directors does and so on. If it doesn't get 100%, it has only the governance authority that is written into the Articles of Incorporation and bylaws for a majority shareholder. So a hospital may have an interest in making certain that it has a full transaction. Now, that's true of an asset deal as well, but it has a bit of a different flavor in a stock deal. It's also true that people who are shareholders as of the date of the deal are the ones who are going to get paid. Anybody that has shares, that expects to get shares next month, doesn't have them now, and no money's going into the corporation that the corporation can send to those non-current shareholders who have some kind of emerging interest in the company. Only the shareholders participate. One final little point about stock deals. Stock deals actually may be easier in some sense from the point of view of contracting and enrollment if what you want to do is to maintain the contract and enrollment of the existing clinic. So If the clinic has better contracts with the hospital than the hospital does with third-party payers, and I've seen this from time to time, then the contracts, there isn't any shift. The corporation shifts. The contracts probably don't have anything in them that says that a stock deal triggers new contracting. Enrollment doesn't have to be redone. It just transfers over automatically, and it's quite simple. On the other hand, if the hospital has the superior contracts and your goal is to move the physicians from a lower to a higher level of reimbursement under those contracts, it may make it quite a bit more difficult if you've got a separate for-profit corporation sitting there that has existing contracts. And the third-party payers are becoming quite savvy to the idea that part of the goal, sometimes from the viewpoint of physicians, is to move to a more productive reimbursement system that a hospital may have negotiated. The third-party payer may, in any event, want to resist moving a new set of doctors under the hospital's fee schedule, but it will have more power to do that if there's an existing corporation that simply gets a new owner. Now let's talk a little bit about the corporate practice doctrine. As I was saying, this is an old common law doctrine that exists in many states. Some states have incorporated it in a statutory provision. Most of the time the statutory provision makes it more difficult and complicated. Some states have nonprofit or hospital ownership exceptions, and I've seen several ways of dealing with corporate practice where it is a problem. And one of the ways is to simply try to deal with the nonprofit or hospital ownership exceptions. So if you have a corporation that starts out as a professional corporation and it does not permit non-physician owners to be professional corporation owners, but the corporate practice doctrine does permit a nonprofit or hospital owner, what some people will do is to attempt to drop professional corporation status, and that can be done in some states and not others, maintain a business corporation, perhaps revise the articles of incorporation or bylaws to limit the purposes of the corporation to acting on behalf of the hospital or nonprofit, and take the position that the doctrine permits a nonprofit or hospital to operate a clinic, and therefore there isn't a requirement that this be a professional corporation. This is a really state-specific approach. Really is going to require lawyers to analyze the existing law and see if there is a way to take a strong position that a professional corporation isn't required after the acquisition of stock. Another approach to dealing with corporate practice when you have a state that prohibits a non-physician owner of a professional corporation is to go out and find a physician owner, and that's called the friendly PC model. The idea is the stock of our physician clinic is going to be acquired, and it's because a hospital is prohibited from owning that clinic, a physician loyal to or friendly to the hospital will be nominated to own the stock. That physician is loaned the money, effectively, to buy the shares of stock, owns it for the benefit of the hospital, exercises his rights or her rights in governance on behalf of the hospital, and provides all financial benefits of ownership to the hospital. Now this is obviously a bit of a Rube Goldberg approach. It's done frequently, but it does have some risks, and the risks are basically twofold. One, that somebody says, we're going to disregard the existence of the professional in the middle and say that the corporate practice doctrine has been violated. That is a possibility. The other possibility is that the nominee physician, some years from now, decides that he or she has rights and that those rights need to be recognized. And the rights would be rights to governance and or some kind of financial contribution for his participation in this arrangement, different from what the documents say. Both of those risks are probably something that a lawyer can deal with in documents, but probably not 100% eliminate in the documents. A third approach, which I guess is a potentially creative approach, is to say, let's acquire the stock of the professional corporation and move the employment of the physicians to another taxable corporation that the hospital can own. And one taxable corporation that the hospital could own is a non-profit professional corporation. Now, these don't exist in every state. Many states, professional corporation means by definition a business corporation. But in most states, the professional corporation law permits a foreign professional corporation to practice in the state. And so one way to deal with this corporate practice doctrine coupled with the professional corporation law is to say, let's have the doctors move their employment to a corporation such as a Minnesota professional corporation. It can be a nonprofit corporation, meaning there's no physician owner, and that nonprofit professional corporation can operate in another state under the foreign professional corporation permission. So what's in effect happening is that you're choosing to use a form of professional corporation other than the local form. You're choosing a set of laws that comes from a different state, but that still authorizes professional practice, and that authorizes professional practice through the vehicle of the foreign professional corporation permission in the local state. Okay, well that seems like a pretzel, and it is, but it's a tasty pretzel with a lot of good salt on it.
I would have to say, this is just Glazer, I want to interject. This, when I first heard it, this is a chocolate-covered pretzel. This is where I think Steve is way smarter than me, and I thought, I'll never come up with stuff like this. But that's a great solution to some of these problems in other states.
All right. We're going to see a lot of stock deals because of the pressure that is created by the corporate tax law, at least in the context of a situation where there is a significant intangible value. There's another way to deal with this intangible value that's a structural way, and that is to analyze whether the intangible value actually is owned by the clinic that's selling, or whether the intangible value is all or part owned personally by the physicians who are selling. So if you have an asset transaction, you can say we're buying a set of assets from the clinic, and that's the tables and chairs, the computers, and so on. And we're also entering into a separate transaction with the physicians in which we purchase the personal goodwill that they have developed to benefit the business. That personal goodwill is, in the proper situation, a capital asset, and those physicians will say, we will be taxed on that portion of the transaction as a long-term capital gain. So to the extent that the value in the transaction is properly associated with the personal goodwill that's owned by the physicians, this kind of transaction approximates the tax treatment that happens in the stock transaction. Now, personal goodwill is something that has been recognized by the tax court in a line of cases, and the case that you want to go back to and look at that's probably is the most important one is the Martin ice cream case, and I've left the site down there. It is also interesting to note that the IRS has attacked personal goodwill deals in some context. There have been a number of rulings recently in which they've said, you did not show us that there is personal goodwill. The structure of the transaction does not reflect a purchase of personal goodwill, and the other details that surround the way the company operated before the transaction don't jibe with the idea that there is personal goodwill that could be obtained. And you know, a lot of this is making sure that the lawyers are documenting this kind of an arrangement in a way that tells the story properly. And if you look at the transactions where the IRS has rejected a personal goodwill argument, they are frequently transactions where the documentation is terrible. for example, there isn't a purchase agreement or there isn't a non-compete that's understandable. It is really important to understand that the existence of personal goodwill and the transfer of that personal goodwill is really related to what the physician could do before or after the transaction to compete. So if there's a strong non-compete that the clinic has before you buy the clinic, that probably means that the clinic has structured its business so as to say, we, the clinic, own the goodwill. Doctor, you don't own the goodwill, and we can prove that we own it and you don't, and the tax court could take the position that the clinic owns it and the doctor doesn't, because the doctor can't take the goodwill someplace else and compete, can't go across the street. So it's a negative factor if there is a non-compete that's applicable before the transaction. Same thing happens on the other side. If the transaction happens in a way that allows the doctor to keep the goodwill, in other words, to quit and compete, then arguably that personal goodwill hasn't been transferred. So having a non-compete as part of the transaction is important to the determination whether there is personal goodwill. Last point about this, really valuable to have an appraisal and to have backup on the idea that the personal goodwill exists and has a certain value. And I'm going to come back to this appraisal point in a minute. Okay, a couple more interesting transaction ideas. When we do an acquisition of a clinic as a hospital, we're relying on the Stark isolated transaction exception. And the Stark isolated transaction exception is an interesting one. It's a very short one. And it basically says you can have an arrangement with physicians in which you buy something or engage in some transaction as long as it's fair market value and commercially reasonable. And those are really separate points. The idea is you are buying something that's worth the money that you're spending, and it makes sense for you to buy that thing. It isn't simply enough that it has the value associated with it. Commercially reasonable, that second point, means it makes sense for the buyer to buy the thing that he's buying. The purchase of a clinic isn't the only thing that the isolated transaction exception could apply to. It could apply to lots of other transactions, and certainly other transactions in which some interest or some item is being bought by the hospital. And so there are a couple of other interests in a clinic that you could conceivably buy and use this isolated transaction exception in Stark. One is a minority interest. We're going to move on in a minute to the idea of purchasing an option in the clinic. Either of these things has got some subtlety to it, and really it isn't easy to come up with a formulaic approach to what to do in proposing to buy a minority interest, or whether a minority interest will seem to be at fair market value and commercially reasonable. It's really interesting to think about this because professional entities are not like Wall Street corporations for which there's a ready market for the stock. People who buy stock in a professional corporation don't do it with the thought that they're going to have an asset that's readily transferable and that they can realize on at any time. They buy it because they are investing in a business that they have an interest in, and it's a financial or a non-financial interest. So if you are a hospital and you're saying, well, we think that it's appropriate for us to buy 40% of the stock of this company, we have to be able to say, for Stark purposes, that we're paying the right amount per share of stock and that it makes sense for us to buy 40% of the stock of a clinic. And what does a hospital get when it buys 40% of the stock of a clinic? Well, presumably it gets a seat at the table at the board of directors of that company. It gets some voice, if not an authoritative voice in what strategic decisions are made, how physicians are employed, what happens in the future of that clinic. And it may have some expectation of a further stock acquisition. So it may say, we're buying 40% of the stock, and we, in some circumstance, may buy the remaining stock of the corporation. It also may say, although we're buying 40% of the stock and we expect to have a seat at the board, that's not enough. We want to make certain that our investment, which really is a sort of long-term investment when you talk about non-marketable stock, is preserved. So we need to have a governance structure that permits us to make certain that this clinic that we own an interest in isn't wasted. And so what the hospital gets is a package of rights. They're rights that might include a return on investment. They are rights that might include a regular minority seat in governance and maybe some supermajority powers that allow it to make certain that the clinic isn't wasted. A similar kind of an interest is an option. In fact, the minority interest might be coupled with an option. The option, like the minority interest, is hard to value for purposes of fair market value and requires you not only to say our price per share was reasonable, but that we had a good reason, a commercially reasonable purchase was done. So both of those things have to be done. In figuring out whether fair market value has been set for the shares of stock, what typically happens is the whole clinic is valued, and then the appraiser applies some percentage reduction on a per share basis to reflect the reduced marketability of the stock, and either an option that is sold to a hospital or a minority interest reduces the marketability of the remaining stock to somebody else. And really, if there's a supermajority requirement for any further sale or any other restriction on a further sale, that's a pretty significant reduction in the marketability and suggests that the right, the minority interest or the option is material. I want to talk a little bit about appraisals quickly, and I'm going to go through 3 more slides and then pass this over to Jim and I'm going to try to hit some high points here. Appraisals are a really tricky subject in any acquisition. There's an IRS CPE article from 1996 that's kind of the touchstone of valuation of medical practices. It's the one that really says, points to a mechanism for doing a discounted cash flow approach to valuing the goodwill of a business. I think it's important to make clear that that mechanism works when you're saying this is the goodwill that attaches to a clinic we're purchasing. It doesn't work when you say this is the value of a separate business that physicians refer to and they're selling from the clinic to the hospital. If you try to say the goodwill of for example, an ASC or an imaging business is being transferred with the transfer of that business from the physicians to the hospital, it simply looks like the value of a stream of referrals, and this method is not useful. Probably the best way to deal with, on either side, valuations that come from an appraiser is to get the early work papers of the appraiser, look what they're doing to value intangibles. It is either going to be discounted cash flow or some kind of replacement cost method, and then use those things to create an allocation of value. The tangible assets are valued the way either at book value or at some market value that is more easily determinable than through this discounted cash flow mechanism, and the intangibles are valued under discounted cash flow. That probably gives you a more accurate measure. It's also probably sensible for the parties and especially the lawyers to try to obtain and to have all their sort of written communications suggest that there's a spectrum of values that is pointed to by the appraisal, not just a single value. I think it's important to remember that there are huge assumptions that happen in the discounted cash flow method, assumptions really primarily regarding the growth of the clinic's revenues and the discounting factors in the clinic revenues, they can make an enormous difference in the values that are created out of the appraisal. I'm going to flip away from acquisitions for a moment and talk about networks as an integration strategy. A lot of people think about the network when it turns out that they can't really come up with a closer integration model. A couple of things that are important about the use of networks. The antitrust rules, that's the typo that I did not find a minute ago, are basically old rules. They're the antitrust safety zones that were put out by the FTC and the Justice Department 10 years ago or so limit a network restrict it from negotiating on behalf of every member of the network unless you're in a particular safety zone. The safety zone requires that you not have huge market power and also have either clinical or financial integration. A lot of people have been thinking about clinical integration, and in fact, in some rulings in the last few years, the FTC has said we approve of the idea of a network that features clinical integration, not necessarily just financial integration. And although there isn't a significant change in the law on this, or even a lot of law about what clinical integration means, it undoubtedly means something involving data collection and analysis, the development of practice protocols, and oversight of the practice patterns, which means some enforcement of practice protocols, some mechanism to say to the FTC, we have entered into an arrangement that has the potential to lower costs and increase quality. If you can argue that you're doing both of those things, then the FTC is likely to leave you alone. And clinical integration is probably I would say is a powerful way to make a network more than just a word. Now here's the thing that I think is one of the most interesting things that's happened recently. ACO waiver regulations came out, I'm going to say last week. They were very interesting. When the ACO regs first came out, I think everyone said, well, this program has a huge risk, a huge cost, and almost no return. So there isn't any reason to do an ACO. And the proposed waivers that they had set up, and these are waivers of the Stark and anti-kickback laws, were extraordinarily thin gruel. And a lot of people put in comments and they said, if you really want to make ACOs happen, what you should do is say the Stark and fraud and abuse rules simply go away when people are participating in an ACO. And that's almost what they did. When they came out with these rules, they basically said, if you are getting ready for shared savings program participation, meaning that you're within a year of applying for participation, you can determine that you have put together a set of arrangements that are reasonably related to the purchase of the shared savings program, document that fact, and the ACO statute will waive the Stark and fraud and abuse rules for purposes of your arrangements. That means if you've done something that does one of these three things, promotes accountability for quality, costs, and care, manage and coordinate care for Medicare fee-for-service, or encourage investment in infrastructure and design of care processes, Stark and fraud and abuse don't apply. That's for that year pre-petition or while you have a shared savings contract. Think about this concretely. It means that if a hospital wants to give an EHR system to a clinic that's participating with them in an ACO and do it 100% and provide hardware, not just software, and provide other things that create the infrastructure for the care process and promote these other things, the waiver will apply. And that can mean Stark and fraud and abuse is off the table for relationships between those parties. That's a huge reason to do an ACO. We never had one before. We never had a reason that was very big. Now we've got something that is going to suggest, I think, to everybody that is interested in propagating a big EHR or engaging in other sort of joint capital projects, this is the forum for that. All right, thanks for wading through all that stuff with me, and Jim is going to keep going with what we do if those things don't work.
Thank you, Steve. I'm going to talk for the next 20 minutes or so on professional service agreements, or PSAs. Professional service agreements are probably the most popular way to integrate an independent physician practice with a hospital. And I wanted to spend some time talking about the PSAs and the pros and cons and some of the issues that are likely to come up with PSAs in the future. So what is a professional service agreement? Professional service agreement is a situation where a clinic sells its assets to the hospital, but the doctors continue their employment with the clinic. So the doctors remain where they are today. The hospital will bill for all of the work that the doctors do. So the clinic is no longer going to bill for the doctor's services. Instead, the hospital will do the billing, and then the hospital will pay the clinic for the work that the doctors do under the professional service agreement. So it's an asset sale, as Steve described earlier, is one of the different ways of affiliating with clinics. It's an asset sale, but instead of the doctors signing employment agreements with the hospital, they'll stay employees of their own clinic. And then the hospital will pay the clinic a bucket of money that the clinic will then use to compensate the doctors. The reason why PSAs are favored by clinics, favored by the hospital, the group that's being acquired, favored by the clinic, is that the doctors can remain employees of the clinic. They won't become employees of the hospital. So they still have the ability to use their name, to meet as a board, to make decisions about who's going to become a shareholder, to be involved in decisions about hiring and firing. They make decisions about how they're going to allocate the pot of money being paid by the hospital. They still have a fair degree of autonomy in terms of making those decisions. PSAs are also favored by the clinic because they would keep their employee benefit programs. So they would keep their 401k, they would keep their health insurance, they would keep their medical reimbursement programs. And in fact, because the employees of the clinic, other than the doctors, are going to work for the hospital, the doctors would have less expense in terms of contributing to those benefit plans because it's no longer going to have its staff. They're employed by the hospital. So they might even be able to make greater contributions to the retirement plan than what they would otherwise have done had those staff employees stayed with the clinic. So greater autonomy, opportunity for better benefits are why they're favored by clinics that are being acquired. The reason why PSAs are favored by the hospital or health system doing the acquiring is that it's a less threatening way to the doctors to become part of the system. If the hospital said, you know, we want to employ you, doctors may be skittish about that. That may be too big of a jump. They may be worried about that in the future, and it just feels better to them to continue employment with their clinic and then have the clinic get paid by the hospital. So a little more autonomy, which is why these have become so popular. There are many things to negotiate in a PSA, and in the next few slides I'm going to hit the high points and some of the key issues for you to think about as you work through one of these. First of all, you're going to be selling the assets of the clinic, so you're going to need to decide what the purchase price is for the sale of those clinic assets. Oftentimes in a PSA, what I see is that the hospital will basically offer to pay a purchase price for the hard assets. So the furniture, the fixtures, the equipment, the accounts receivable. And the hospital will not be offering to pay for the name of the clinic, that stays with the clinic, nor does it typically offer to pay for the value of the workforce in place that it's acquiring. So oftentimes in a PSA, the amount that the hospital is paying to acquire the clinic ends up being less than if the clinic were to be sold as a whole and have all of its employees, including the doctors, become employees of the hospital. So another little potential benefit in a PSA is that it might afford the opportunity in negotiations for the hospital to offer a price that would be less than what it would have paid had it acquired the whole clinic in the normal sort of clinic acquisition. Secondly, another item to negotiate is that if the doctors do a PSA and they stay employees of the corporation, one of the things that you'll oftentimes see is that when the PSA is going to terminate, the doctors theoretically could go to work for another healthcare system. And part of the PSA might say that before the doctors decide to become employees of another healthcare system, they'll give the current hospital a right of first refusal, an opportunity to match whatever employment offer or whatever other kind of PSA goodies another system might be offering, give the current hospital the opportunity to match that in the event that that should happen. How could this happen? Let me give you an example. Let's say that you have a community where there's a small community-owned hospital and a group of doctors, and they decide to do a PSA. So the small local hospital buys the assets of the doctors stay employees of the clinic, and they work under the PSA. 3 years later, the term of the PSA is up, and the doctors are not required to go to work for the hospital. They're basically free agents. So the hospitals make an inquiry with one of the larger health systems in the area, and that larger health system, seeing an opportunity to maybe acquire this community clinic and hospital, say to the doctors, you come to work for us, and then we'll negotiate a deal with that hospital where we'll basically acquire it. That would be a situation where the local hospital probably would have liked to have some sort of opportunity to have those doctors become its employees at the end of that contract. So one of the things in the PSA to think about is what happens when the PSA is over and does your hospital have the opportunity to match a competing offer by another health system should that come to pass. The right of first refusal is basically what that's called in that kind of a situation. The term of the PSA, most PSAs that I deal with tend to have a 3-year term or maybe a 5-year term, but they're typically not a long-term agreement because people simply don't know how long the physician compensation model in these PSAs is going to remain viable. So they typically have a relatively short term, 3 years with maybe an automatic renewal unless one side or the other gives notice of non-renewal. Other items to negotiate and something to bear in mind is that if the doctors will be using a facility that was financed with tax-exempt bonds, for example, the hospital itself, put up with exempt bonds, there's an IRS revenue procedure that describes safe havens in terms of what the term of these PSA-type agreements can be. And most bond attorneys like PSAs to fall within these safe havens. That generally requires, in a type of PSA that we typically see, that the term not be for more than 3 years and that the hospital have an option to terminate the PSA if it wants to at the end of 2 years. It can be renewed for as many periods as you want, but the term itself has to end in 3 unless it's renewed by mutual agreement. Hospital has to get out at 2, and that's under the IRS revenue procedure dealing with tax-exempt bonds. Another thing that gets negotiated a lot in PSAs are what are the other early termination events. And some of the things that we typically see and work on in these kinds of situations is, well, what if that hospital becomes part of another healthcare system? What if, in my example, this community hospital decides to sell out to a larger system? The doctors may want an opportunity to renegotiate their PSA because their partner that they thought was the local hospital is now a bigger healthcare system, and maybe they want to cut a different compensation package with that health system. So a change of control event might be an early termination or reopener event. If the hospital cannot obtain provider-based status, a lot of these affiliations are premised on the hospital being able to bill for the clinic's services in the future as a provider-based clinic. That's where the hospital is going to come up with the money to pay the doctors a higher rate of pay than what they've been paid in the past. So if the hospital can't get provider-based status, or if the laws change and provider-based status isn't the kind of economic program it is today, that may be an opener in the PSA. That really leads to the third bullet point, There may be a reopener if there is a significant financial stress that comes to bear on the hospital system. Many of these PSAs that are paying the physicians more money for pay than they'd been paid in the past are premised on things such as recruiting new physicians to the community, having provider-based status, having continued reimbursement at current levels with Medicare and Medicaid, and so forth. So if those sorts of things come to pass, then the hospital may not be able to afford what it promised to pay the doctors in the PSA, and that'll be an item that would have to be negotiated. Those kinds of openers oftentimes are measured with reference to the bond covenants. You know, if the bonds require that the hospital have 60 days cash on hand, and if as a result of financial stresses the hospital's going to fall below that, you know, that may be a reopener in the PSA for the hospital to renegotiate compensation. Then the doctors will likely say in response to these sorts of things, A, they may say, no, we don't want these reopeners at all. The hospital will need to be at risk. Or B, if there are reopeners, there should be some sort of cap on where our compensation goes. And we wouldn't want it to decline by more than, say, 10% if there's a reopener for financial stress. Still more items to talk about in a PSA. There typically is a clause that says that if the laws change and causes this to become illegal, we'll negotiate in good faith a resolution to that. That's a pretty common clause to include. We'll have to talk significantly in the PSA about what this compensation model is going to look like to be paid to the clinic for the doctor services in the future. In the past, and pretty typically, these have been based on work RVUs. So the number of work RVUs generated by the doctors, you know, times a conversion factor, you know, equals the amount that the clinic is going to get paid for their services. And that's usually spelled out for at least the first 2 or maybe 3 years of the PSA. The conversion factor is usually set. The conversion factor may vary based on how many RVUs the doctors are generating, but that typically is spelled out in the PSA. Those are then verified by looking at compensation surveys to establish fair market value. But remember in a PSA that the doctors are still employees of their own clinic. They're not employees of the hospital. So in addition to the amount per relative value unit, the PSA is going to need to describe an amount the clinic is going to be paid for employee benefits, things like the doctor's health insurance, for their malpractice, for their disability insurance, for their payroll taxes. So the PSA is going to have an additional amount above and beyond the pay per work RVU to cover those expenses. But you also have to bear in mind, whether you're looking at this through the hospital lens or the clinic lens, that the clinic may have other expenses as well. There's going to be expenses to prepare the clinic's tax return each year. There's going to be other minor amounts to keep the clinic in effect. And so when you're designing the PSA, you have to remember that there are going to be other operating costs that that clinic is going to have in the future. And you need to find some mechanism to either have an understanding that the doctors are going to need to pay that because that is their clinic and that is one of their expenses, or you need to have enough cushion subject to fair market value and the pay rates that will net the doctors an amount that they'll still be happy with. So you need to bear in mind that PSAs do continue to have these other expenses. Another biggie in negotiating a PSA, I think, is who's going to employ the mid-levels, for example, nurse practitioners and physician assistants. There's a trend among some health systems to start looking at using PAs and nurse practitioners to provide staffing of things like urgent care centers, potentially other aspects of a clinic's practice. And so one of the strategic questions for the doctors to decide is whether they want to continue to have the contract to supply the mid-levels or if they're willing to let that go and let the hospitals employ the mid-levels. Likewise, in a PSA, is this relationship exclusive? Could the clinic, in addition to the hospital, provide services to another hospital? This is oftentimes the case with specialty groups, for example, a radiology group. They might have a PSA with one hospital, and they may have a PSA with another hospital, or they may be billing on their own for other hospitals. So you could have a mixed bag with some specialty groups where they visit different healthcare systems. They may have a PSA with one. They may not have PSAs with others. In that regard, and I don't mention that in my bullet points, clinics that do multiple PSAs, while they're also billing for ancillaries, need to bear in mind that they have to be sure they comply with Stark when they bill the ancillaries that they're still billing to Medicare. The PSA will also need to talk about what are the obligations and coverage in terms of hours, call, if you're covering the ER as a part of this, urgent care, hospitalist, and so forth. But the biggest issue with PSAs is what happens at the end of the PSA terms. And this is what I think is really interesting about a PSA situation and what's so different from an employment situation. When a hospital employs the physicians, when it comes time for a doctor's employment agreement to expire, the hospital can simply negotiate those on a one-to-one basis. There's no obligation on the part of the hospital to negotiate with its doctors collectively. It can talk to each one separately. In fact, it could talk to each one separately and say, don't talk to any of the other doctors about what I'm renegotiating in your employment agreement, or we're going to be taking that very seriously. With a PSA, however, the hospital is going to be negotiating with all of the doctors through the clinic's board of directors. So it certainly raises the stakes in terms of what's going to happen now at the end of the PSA term. Now, of course, if the relationship has done well and the finances are good and everyone's happy, there's no issue. It'll mutually agree, people will automatically renew it, and all is well, and lawyers never get called. But it could be a situation where the parties are unhappy, that the doctors feel they deserve continued high pay, but the hospital has been facing declining reimbursement. The doctors fault the hospital because the hospital didn't cut things that the doctors felt the hospital could have cut. The hospital said, I'm sorry, we have a collective bargaining agreement with our nurses and we can't cut it. And that's just the way it goes. So in a situation where the relationship is unhappy, this is where the PSA becomes quite interesting. So in that sort of heated environment, how do you negotiate these new rates? And there's no good model or practice out there yet because we're really, frankly, still in the early stages of these PSAs. But one of the things that I think holds some promise is to bring in an independent mediator, to bring in somebody from outside who has experience with other groups and PSAs, and for them to recommend what that new compensation model should look like. You could even go so far as to have that set by binding arbitration if you really wanted to be brave enough on both sides to turn it over to an arbitrator. You might also provide in the agreement sort of a cooling off period, that for a period of 1 year, instead of it coming to a hard stop, we'll take last year's rates and bump them up by a cost of living factor just to give ourselves a cooling off period. Really, as I said, at the end of these PSA terms, when the situation is dysfunctional and people are pointing fingers, it reminds me of the term back in the 70s where the United States and the USSR had all their missiles aimed at each other, and we had that term called mutually assured destruction, or MAD. And that's what I think about in these dysfunctional PSAs, that it's a situation that can't continue that way because the doctors won't want to become hospital employees because they're angry and upset. But the physicians can't go back into private practice because they can't afford it. And they don't have consensus within the clinic. Some doctors may want to go back into private practice, others don't. So they can't reach consensus, but they certainly don't want to go to work for the hospital that they're really mad at. So that's a really stressful time, I think, potentially in some of these dysfunctional situations. Probably what would happen is that the whole health system is going to need to look to another health system who could come in, be a white knight, and rescue the situation. But that's really the big risk with PSAs in terms of how that showdown scenario could evolve. Other things that could go wrong with a PSA is that I could see situations where the hospital says reluctantly, okay, we need you doctors to supply the hospital, and we don't want you to quit and leave the community because then we're going to have fewer doctors and it's going to even be harder to recruit, so we'll pay you. We'll pay you. We can't force you to buy back your clinic. We can't force you to be our employees, so we're reluctantly going to pay you under renewed PSA at rates that we, the hospital, think actually may be more than fair market value. Well, that's a problem. If it is more than fair market value, the hospital may be running afoul of its tax exemption requirements or potential anti-kickback issues. So that's a situation where if that's going to happen, the hospital's going to need to talk to its attorneys about how to set up this renewal agreement in a way that will be defensible from the perspective of those laws. Another thing that can go wrong is, remember how the doctors thought that they would get paid that amount per work RVU plus their benefits and they'd make more money than they were making today? Well, what happens if the clinic does have an expense that nobody really anticipated? For example, the clinic terminates one of its doctors for poor performance. Hospital says to the clinic, you know, we don't think Dr. Smith is doing a very good job. You need to get rid of him. Clinic says to Dr. Smith, here's your 90 days notice. You're fired. Dr. Smith then turns around and sues the clinic. The doctors are going to say to the hospital, you know, you're going to have to pay our legal bills to defend this because otherwise we're going to take a pay cut. The hospital would say, well, what does the PSA say? It doesn't say we pay your legal fees, clinic. That's your expense. So again, there can be a situation where the doctors unexpectedly have clinic expenses that they didn't anticipate when they entered into the PSA. Another one is that benefit costs are going to exceed what people thought were going to be the case in the PSA, especially with health insurance. You know, people will try to set what they think the initial rates are going to be for a 3-year term, and you get out after 1 year and you already find that the benefit costs don't work under what was agreed to in the contract. So you have to either work out a new deal or tell the doctor that's tough, that was the deal you struck. Other things that could go wrong, there's a tax risk lurking out there, I think, for some PSAs, and that is whether the doctors are really employees of their clinic or if in fact they're employees of the hospital or health system. You know, the IRS employs a 20-factor test to determine whether somebody's an employee or an independent contractor. And the argument here that the IRS would make is that doctors, you no longer have any overhead. You no longer have any expense. You don't own equipment. You don't own furniture. You don't own fixtures. You are really effectively employees of the hospital. In fact, your PSA says that the hospital can hire and fire and cause you to do all kinds of things, and the money is really coming over from the hospital and not really originating with the clinic. So the IRS might take the position that the doctors are employees of the hospital. Well, the biggest negative to that for the doctors is that if they were contributing to their own retirement plan at a high rate, that retirement plan could become disqualified, and the benefits that the doctors thought were tax-free could then become taxable. On the other side of the spectrum, the doctors would say, no, we are employees of our clinic. The PSA says that the clinic makes decisions about who staffs these offices, what we pay ourselves internally. We're a big clinic. This isn't a situation where we're talking about one doctor. We're talking about 30 of us. So we truly are all employees of our clinic and not individually employees of the hospital. There's a variety of cases out there on this topic, and in the 8th Circuit Court of Appeals, where Minnesota and the states in the upper Midwest are located, the case law is in favor of characterizing the doctors as employees of the clinic. But that's something that could change and something that needs to be looked at when you do a PSA. Antitrust is another interesting issue. There's something referred to as the Copperwell Doctrine, where it was established by the courts that a corporation cannot conspire with its wholly owned subsidiaries because the parent owns and controls a subsidiary. So there's no risk of a group boycott or a price-fixing claim by a third-party payer or otherwise, because a parent and subsidiary is really one entity. Well, with PSAs, there's a question out there about whether it is really one entity, because if the clinic really controls its own internal decision-making processes, as I just described, you know, are these really still two separate organizations that are contracting with each other and that still have the ability to engage in antitrust violations? Other things that could go wrong with a PSA, obviously overpayment, underpayment disputes. So language issues in the PSAs that the doctors were overpaid or the doctors feel they were underpaid. You usually include then in a PSA a dispute resolution process. I strongly favor arbitration over litigation so that you can get an arbitrator who understands and has the time to understand the sophisticated issues that are involved in these kinds of contracts. Using an independent mediator first to sort of informally try to resolve the dispute is always a good idea. And of course, the hospital's worst case nightmare in the PSAs is what's the practical reality of being able to sue your own physician group in a PSA. Really, really a difficult, uncomfortable, ugly situation when you do PSAs. PSAs, for these reasons, really are transition vehicles. I think that long-term, the better model other than a PSA is a more integrated organization where you've got effective management, effective MD leaders, you've got real meaningful joint governance, and that together you've got an organization that is functional and that's been able to address the future reimbursement issues that are coming. So with that, that's what I think and what's going on with PSAs. David now will wrap up with his topics.
Good afternoon, everyone. So I'm David Glazer, and I'm your caboose today. And that's kind of fitting because just as the railroads brought a great deal of profit into the world, they also cost some people their limbs. And the same is true of relationships with drug and device companies. Basically, you can make a lot of money off of the relationship, but right now, every now and then, it's someone's going to be giving up a limb or more. And I don't think it's any rocket science to say that there's a bunch of new enforcement and reporting. The government has made it quite clear that they want to pick on physicians that have relationships with the drug companies or device companies that the government feels are improper. As part of health reform, there's the Physicians Sunshine Act that says by 2013, anytime value is transferred from a device company to a physician, then value is defined as anything over $10. It's got to be reported to a database. It's just something to kind of keep in the back of your mind. And increasingly, states have laws like that. If you get nothing else out of this, I think one thought you need to think of. Okay, something that you need to do to prepare for trouble is to make sure that everyone in your organization would know what to do if this happened to them. So I had a physician who was located in kind of the middle part of the country who got a subpoena from the U.S. attorney in Atlanta. And it was interesting, the doctor, to my relief, didn't actually read the subpoena. He assumed it was a malpractice subpoena to testify in a malpractice case. So he called me up and said, I'm going to be out of town on this day, David. Can you just call up and take care of this thing? I read it and discovered, in fact, it was a subpoena from the U.S. attorney, and it was a grand jury subpoena. And it included this very disturbing sentence. The United States attorney requests that you do not disclose the existence of this subpoena. Any such disclosure would impede the investigation being conducted and thereby interfere with the enforcement of the law. Well, if my physician had taken the time to read the subpoena, there's an interesting question as to whether he would have called me. Because this says very clearly he can't tell anyone about this subpoena. I think this language is per se unethical for a lawyer to send out. They're not supposed to tell people. They can't talk to folks. And generally speaking, you can tell anyone you want to about a government investigation. There's basically two exceptions to that, and they're terrorism and certain bank investigations. Nothing in the healthcare industry would prevent someone from talking about an investigation. But if one of your, doctors, executives, anyone in the organization got a subpoena like this, they need to know they can call you. And the only way you can deal with that is ahead of time. So this is a risk management tip, which is train people to know that even if they see language like this, they can call you. And so for what it's worth, this was a device investigation. And what they were investigating were payments from a device company based in Atlanta to physicians around the country. So Neiman Marcus or Marshalls. And it's the question of an off-label use. This is one area in the both drug and device world where we're seeing a great deal of attention. Off-label use is permissible. Doctors can do stuff off-label, and that's fine. The problem arises when a drug or device company asks a doctor to be giving advice about off-label use because it's improper to promote an off-label use. And so the speech which is talking about an off-label use can be a problem, whereas a physician saying to a patient, I recommend you do this off-label use, is just fine. So physicians everywhere need to understand, and hospitals everywhere need to understand, that promoting an off-label use is problematic, and it's maybe the number one area of enforcement right now in the drug and device world. So people have to pay attention to the label, and physicians, because they can use stuff off-label. The classic example of that in the old days was aspirin. recommending it to treat heart. Now, I believe aspirin is labeled properly to cover heart-related uses, but in the old days it wasn't. It's perfectly fine for a doctor to say you can use this drug off-label. They just can't promote the off-label use, and that the conversion to promotion is basically compensation or something like it. Are you required to disclose the off-label status to patients? Whether you're a hospital or a doctor, that is not a legal requirement, but I would strongly recommend it, and I think that is something most of you guys probably already know. I'm going to spend a minute talking about physician-owned distributorships, which are often referred to as pods. Pods are an interesting idea. It may be a great mechanism to lower device costs. I'm certainly intrigued by it. The idea, for those of you who haven't heard of it, is that a doctor becomes responsible for either the production of or the distribution of a device. They then contract with the hospital and to provide the device, and the theory is that it'll lower marketing costs, it'll lower markup, and that basically the physicians can choose the device they want to use, cut down on the general costs of the system, the hospital can save money, the physicians might make a little bit of profit, and everyone comes out ahead. There are several well-distributed legal opinions. It's amazing. I think if you've had anyone in your organization talk about a physician-owned distributorship, you've probably seen at least one of these opinions. My personal opinion, one of them is, I've seen three that I can think of. Two are from law firms saying these are fine. One was well-written and fairly impressive. One I thought, frankly, was drivel. Then there's another one that's written by a company, or by a law firm that was retained by the device companies that says these things are illegal automatically, you can't do them, and entering into them is basically guaranteed death. I come down somewhere in the middle on this one. I think it's an extremely intriguing idea. It's worth noting that the government solicited comments from people, and I want to say that they solicited these comments in like 2005. I'm looking at Steve and Jim and seeing if they remember the date, but it was a long time ago. I think they solicited comment in like 2005, and here we are 6 years later, and the government hasn't opined on it yet. And do you draw a positive or negative inference from that silence? So I think the idea is extremely intriguing. This would make a great law exam question. The problem is it definitely is risky. This is the sort of thing that if you enter into it, you know that someday there's a shot the government tries to make an example out of you. So I'm intrigued by the idea of a pod. This is one of the few times in my life personally where I'm reluctant to enter into one without getting an advisory opinion from the government. I don't really generally believe in advisory opinions as a firm. We haven't done very many of them because we think they're usually a waste of time. We've done a couple. But this is one situation where if I were really serious about a physician-owned distributorship, I would think about asking for an advisory opinion, and I certainly would if I had anyone who is risk-adverse who was interested in participating. So bottom line, there are well-respected law firms and well-respected legal arguments to say this is okay, and there are well-respected law firms and strong arguments to say run. Okay, last thing I want to do is walk through an example and kind of cover some of the typical situations that come up in hospitals and clinics in relation to devices. So our company, DV Us, has developed a new medical device, and this medical device can treat post-surgical pain. So they're trying to get this thing off the ground. The devices are used immediately following surgery in the hospital and also in a clinic. The hospital is convinced that there's a CPT code that describes the device, and they now want to get the hospitals to try it. So they're going to dispense it. When used in a hospital, the presumption is that this device is part of the DRG. So to crack into the market, here are some of the things that they're trying. So first, they send a mailing to large urban hospitals and say, we'll give you this device for free. In fact, we'll give you 100 of them for you to try out. So you're a hospital, you get offered 100 free devices. Can you accept them, or is it a kickback? Now, whenever you're in the anti-kickback world, intent really controls everything. And so if you look at the intent here, they're trying to get you to try things. They're giving you something for free. I'm not that worried about this. You're not going to fall within a safe harbor, but if a device company says, we want you to try this, try it, you'll like it, here it is for free, I feel pretty good about that. And one of the reasons I feel good about it is it isn't linked to anything else. Linkage is where I get substantially more worried about kickbacks, as we'll see in a couple of our next bullets. So I'd be pretty good with this one. The next one is a mailing to smaller hospitals, and some of them are critical access hospitals. And notice this is an important change. Now we're moving from DRG reimbursed hospitals to hospitals that are paid on a cost basis. And the offer is buy one, get one free. So in some ways, this is a discount. Discounts are okay. What makes this one a potentially more troubling is that as soon as it's buy one, get one free, you have an accounting issue to deal with, which is how is the discount going to be handled internally? Because if you want to make sure that your costs are accurately reflected on the cost report. Now, buy one, get one free shouldn't be that hard for that to happen, because the ones that you pay for wind up on the cost report, the ones that you don't, and things are then accurately reflected. Once again, I'm not terribly worried about this one. You just have to make sure if you're doing it that your costs are handled internally. It's just a discount. Next one is that some of these same hospitals are being told, hey, if you buy 10 of our surgical tables, we'll toss in 100 of these devices for free. Now, this is getting more problematic to me, and one of the things I'm not liking here is the linkage. I don't like the link of two sort of seemingly unrelated things, the surgical tables and the device. Because are the 100 devices here really becoming an incentive to purchase the surgical tables? And it feels like the answer to that might be yes. So I'm way more nervous about this one. The other thing is this seems like a much more difficult situation to account for. I think that those 100 devices have to somehow wind up so that those backed out of the cost of the surgical tables, so that your surgical tables minus what the value of these devices is winds up on your cost report. If you don't do that, I think you have a problem. And even if you do back it out, I'm more nervous about this because of linkage of two unrelated things. A discount on one product, very low risk. A discount on one product in exchange for purchasing another one is, I think, a substantially higher risk. Final one on this slide is a mailing to physicians that says, hey, here are 100 free devices. If you use code X, you can bill for this service and you'll get reimbursed $1,500 for each device. This means the 100 devices will be worth $150,000 to your practice. Now, I don't know how different in some ways Bullet 4 is from Bullet 1, but it feels really different on the risk rheostat. And part of this is intent. Notice how it's being marketed. It's being marketed as this is a gift to you of $150,000. That alone makes this really smelly in my mind, and so I'm running from this one. And it highlights an important question. You can set up a policy, we won't take anything for free. I can understand such a policy, and it's easy to apply, and I know lots of organizations want to go with that, and I can get behind it. But I don't think you need to set up such a policy, because the first bullet on this slide really doesn't worry me much at all. The fourth bullet worries me a lot. If you're willing to take the effort to slice between, or to examine the motives of the participants, you could accept some things for free. Motive matters, and motive is what makes that fourth one sound really bad to me. Now, this next one isn't pro or con in the favorable or unfavorable sense, but in the professional or convict sense of the word. So you've got a physician, and they're told, hey, you use this device a lot, so we're inviting you to a dinner. The dinner is going to cost $100 a head, and at the dinner, we're going to have a drawing for a trip to Europe that's going to be given out randomly to one person there. Can a doctor attend that? You know, you're the hospital's general counsel, you want to forbid your doctors from going to this? Well, the answer to that's what I think I could defend this one, because $100 isn't a giant payment. I don't like the fact that the people are being invited because they used the device the most. If it were a marketing dinner, I'd feel better about it. You know, it's oddly, if they're trying to explain why the device is good, that almost feels better to me than if it's a reward to people who have used the device a lot. You can market, you can't give someone a financial incentive to use your device, and this feels like a reward. Now, the good news about the trip to Europe, I would argue that that would get allocated equally to everyone present, and so I don't think that the value of the trip to Europe is the value to the one doctor who wins it, but rather the chance of winning divided amongst the cost of everyone there. But this is, you know, there's some worry on this, and I feel much more worried about this than I do about the drug rep who brings in pizza while trying to explain the value of their drug. And the reason that one doesn't cause me as much anxiety is I think that pizza itself doesn't rise to the level of being economically valuable enough to constitute much of a kickback. A company offers to pay $2,000 per speech for a physician to talk to an audience of prospective patients explaining the device. The ads are mailed by the company to patient homes, touting the physician's expertise. There are two things in here that I don't like. I'm okay with the $2,000 for a speech. That doesn't make me very nervous. But I don't like the idea of someone getting paid to market themselves. If the physician is talking to prospective patients, or a hospital is talking to prospective patients, that's marketing that generally they would be responsible for. And the notion that the drug company is going to pay them to promote themselves makes me nervous. And I also don't like the drug or device company mailing stuff to patients' homes that is really marketing for a particular doctor or hospital. I'd feel far better about that if that expense were covered by the doctor or the hospital, him or herself. Let's say the company says, hey, we know you're going to get denied on some of these things, so we will cover the cost of any appeal you go through. That I don't feel too badly about. I haven't ever seen an advisory opinion dealing with this, but I also haven't really heard about companies getting in trouble on this one, and it's done fairly broadly, and I feel like that in some ways it's the company standing behind their device. So I feel pretty good about this one. And the last slide I've got is all in the family, and it falls into the category of you can't make this up. Device company says to the surgeon's brother, we're going to hire you as our rep. Now, once again, facts matter. So let's say the surgeon's brother is in fact a really good rep. He or she's been working for years as a rep, and they're really good at this. I feel a little bit better about it then. Still not great, but better. Now, let's say that this person has never been a rep before. They're currently working in a grocery store, and they've got no idea what's happening in the healthcare world, and the device company has hired this person. Well, now we've got an economic relationship with an immediate family member of the surgeon, and my skin's crawling quite a bit. So it kind of highlights how much facts and circumstances matter, but this one is the sort of thing Archie Bunker would yell at his TV about. We've got time for questions. I know Steve and Jim have thrown some really creative ideas at you. I can't say I've done the same, but if you've got questions, you can fire them off. I'll pause and stall for a second to say, don't forget, on December 14th, we've got the next webinar. I'm not exactly sure who from our group will be doing it. It'll be a bunch of people talking about the fee schedule, which does have a few things in it, and then we'll expound a little more on the point Steve was making about ACOs. We were definitely in the ACOs are a waste of time camp, and there's now this intriguing reason you might think about them, and we'll elaborate on that on December 14th. So I don't know if questions are, we're looking light on questions. I was going to ask Jim if the new study about PSAs and their use and how they cause unnecessary medical tests, but I guess that was the wrong kind of PSA. All right, not seeing any questions, we'll bring this thing to a close. You can always email Steve, Jim, or me, and thank you much for joining us.